how comfortable are you with that? I mean, as you know, as a practicing attorney, an outside counsel, in-house counsel, are you comfortable having a computer system make these designations on documents and producing them just based on statistics without actually having first absorbed the substantive information in those documents?
I think a lot of that depends on, are you the one being sued or are you the one suing? If you're the one being sued and this is new technology and you're going to rely on keywords and rely on what it pulls back, and there's a smoking gun out there, and go for it. Right. If you're the one suing and you want to get a little bit more detail about what's being pulled out, I don't know if I would necessarily be comfortable in relying on the technology to find something. Like if I'm looking at, for example, what I spoke about yesterday, if we're looking at employees that are leaving the firm and we're suing them for restrictive covenant litigation, and they're taking documents and templates and taking them to competitors, and there's very confidential information on that. I want to be very, very specific on what we're searching for, because that's a big deal in terms of determining damages. Whereas if I'm on the other side of that, and you're using this technology for the first time and you're suing us because, we had somebody go to you, for example, or you had somebody come to us, that's fine. I think it really depends on what side you're on when you make that determination. Do you guys, as attorneys, agree to that?
I think it also depends on the size of the case and the volume of the documents. Maybe if 100,000 documents, that's one thing. If you have 3 million documents, that's another thing. And you also have to take into consideration the amount of time that the judge who's case managing the litigation is giving you to do the review of those documents. If you have to review, we have a case in my office, we were given 3 months to review millions of documents. I mean, it's an impossibility. You can't do it manually, no matter how many people you have. So sometimes you don't have a choice, but you're going to have to weigh all of those different options in deciding whether or not it's a good tool in the particular case.
I also think it depends on how well you know your case. If it's a small enough case where you know the key custodians, you know sort of where the bodies are buried, and you can focus your searches, the utility of predictive coding really goes down.
So part of the problem you have here is, and for those people that have been through Six Sigma training, you don't know what you don't know. And you also know that human beings can only be 4 or 4.5 sigma, so 350,000 errors per million opportunities for error, and your computer can get to 6 or beyond, so 4 errors per million opportunities for error, and that's great. And so that says we should use computers all the time to do this for us, because they're going to be far better, far cheaper than having a bunch of young associates do it. The one way that I've broken that paradigm, in the past I had a 3 terabyte, we took every document we could find and we scanned them. It was 3 terabytes worth of documents. And I sat with 15 partners at a major law firm, and it was a bet the company case, so it was necessary to do it that way. But we had 15 partners, and we did reviews of 1,000 pages together, so that everybody was on the same page. And then the partners reviewed the documents, because they knew what they were looking for, they knew how it was going to play into the case. And it may sound like it was more expensive, it was actually cheaper. This was when I was working for GE, and there was a parallel case going on with one of the other divisions, and they did all with first, second, third year associates slogging through the boxes. And part of the issue is, since you don't know what you don't know until you see it, a lot of times it's hard for me to get a computer, in a predictive coding sense, to think like I'm thinking, because I may see something that the computer would say is entirely irrelevant, and I say, this is a weapon that I can use later in the litigation. I need to put this aside and put it in my toolbox and hold on to it. So it's not only in the document review what's relevant and what's responsive, it's also what's useful to me later in my case.